Good evening and welcome to Courts Today by LiveLaw. I am Urvashi Chauhan, and in this video we cover major legal developments from the Supreme Court and High Courts. From FSSAI's food labelling regulations to the Supreme Court's concerns in a high-profile child custody case involving a Russian national. We also look at key rulings on sedition, bail, land acquisition and enrollment fee caps by Bar Council of India. Watch this video till the end and make sure to subscribe and hit the bell icon. A public interest litigation has brought a critical issue to the Supreme Court. How clearly are we told what's really in the packaged food that we eat? Two health advocacy groups, 3S and Our Health Society, approached the court demanding mandatory front-of-pack warning labels. Their concern is rising rates of obesity, diabetes, high blood pressure and heart disease in India, conditions directly linked to excessive sugar, salt and saturated fat in processed foods. They argued that interpretative, easy-to-read labels would empower consumers to make healthier choices and protect public health. Acting on this, the top court had earlier directed the Food Safety and Standards Authority of India, or FSSAI, to finalize its recommendations for such a labeling system within 3 months. That deadline was set on 9th April this year. But now the FSSAI returned to court asking for more time. The bench comprising Justices J.B. Pardiwala and R. Madhavan granted it one last extension, 3 more months to complete the task. The court made it clear that this is the final opportunity. If the committee fails again, the court will take appropriate steps in accordance with law. According to the affidavit filed by FSSAI, work is already underway. Back in September 2022, it had notified draft amendments to the existing food labelling regulations and invited public feedback. Over 14,000 comments poured in from food businesses, consumer organizations, and the general public. To go through all this feedback, FSSAI formed an expert committee in February 2023. After multiple meetings, the committee prepared a report recommending changes, which now needs to be vetted by FSSAI's scientific committee before being finalized. Let me also tell you, the proposed changes include a significant reform, the Indian Nutrition Rating, or INR. This is a star-based front-of-pack labeling system ranging from 0.5 to 5 stars. The more stars, the healthier the product. The idea is to give consumers a quick visual guide about the overall nutritional value of packaged foods without needing to decode complicated charts or fine print. As it stands now, the Supreme Court has given FSSAI 3 more months to complete the process. This could mark a major shift in how food is labelled in India and how we decide what we eat. In the next update, the top court has clarified that when government acquires land for a public purpose, it's not always mandatory to provide rehabilitation to the landowners beyond the monetary compensation that they are legally entitled to. The court said that while the law guarantees fair compensation in such cases, rehabilitation or resettlement should only be considered in exceptional situations, mainly where the land acquisition directly destroys someone's livelihood, like in the case of farmers or communities who are fully dependent on the land for survival. The observations were made by a bench of Justices J.B. Pardiwala and R. Madhavan while hearing a case involving the Haryana Urban Development Authority, or HUDA. So HUDA had acquired land and under its 1992 rehabilitation policy had promised to also resettle the landowners apart from paying compensation. However, the landowners, also referred to as the oustees, were later denied rehabilitation. HUDA argued that the landowners had not followed the proper procedure under the 1992 policy to claim those benefits. But the High Court did not agree and had earlier directed HUDA to provide rehabilitation. But HUDA challenged that decision before the Supreme Court. Well, in its judgment authored by Justice Pardiwala, the Supreme Court has now set aside the High Court's ruling. It found that yes, landowners did not follow the necessary steps under the 1992 policy and therefore could not claim the rehabilitation benefit, even though they were entitled to it in principle. Significantly, the court noted that this case was a classic example of how state governments sometimes float additional rehabilitation schemes to appease landowners in hopes of making land acquisition smoother. But such schemes can often backfire, leading to confusion, litigation, and disappointment for the landowners, especially when benefits are denied on technical grounds. The court emphasized that rehabilitation should not be seen as an automatic right in all land acquisition cases. Instead, such schemes should only be used in situations where people are truly left destitute, when they lose not just land but also their home or livelihood. It also pointed out that any additional benefits offered by the state should be guided by humanitarian values like fairness and equity, not political convenience. Well, I must also tell you here that under the new land acquisition law passed in 2013, the title of which is Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act, now rehabilitation is a legal requirement alongside compensation. But this particular case was decided under the earlier framework where rehabilitation was not necessary. So while the law has evolved, the judgment serves as a caution about the importance of clear policies, proper procedures, and the real-life impact of land acquisition on communities. Moving ahead, in a sensational twist in the Renukaswamy murder case involving Kannada actor Darshan, the Supreme Court has questioned the Karnataka High Court's decision to grant him bail and asked Darshan's lawyers to justify why his bail should not be cancelled. A bench of Justices J.B. Pardiwala and R. Madhavan bluntly told senior advocate Kapil Sibal appearing for Darshan that they were not at all convinced by the manner in which the High Court exercised its discretion in granting the bail. Darshan, as you must be aware, is alleged to have abducted the deceased from Chitradurga, held him in a shed in Bengaluru and subjected him to 3 days of torture. The man later died from the injuries and his body was dumped in a drain. Darshan and several others, including actress Pavitra Gowda, were arrested and later granted bail by the Karnataka High Court in December last year. But the state of Karnataka has challenged this order of granting bail in the Supreme Court by filing a special leave petition, and today the top court issued strong observations while hearing the matter. Senior advocate Kapil Sibal, appearing for Darshan, argued that instead of focusing on the High Court's reasoning, the court should examine the statements recorded under sections 161 and 164 CRPC and evaluate key witnesses, including members of the police. But the court remained firm. Justice Pardiwala responded that you need to convince us that there is no good reason for this court to interfere. Meanwhile, senior advocate Siddharth Luthra, appearing for the state, told the bench that both antecedents and post-bail conduct of Darshan need to be questioned. He submitted that Darshan was seen sitting on the same stage as one of the prosecution's key witnesses at a public event, something he described as disturbing. The case has now been adjourned till next Tuesday, with the top court expecting strong arguments on why Darshan should remain out on bail. Many marriages today end in divorce, and it's become increasingly common. While divorce proceedings can be exhausting for the couple, they often leave an even deeper impact on the children, especially when it comes to custody battles, which can turn into long, emotionally draining fights with the child caught in the middle. One such example came before the Supreme Court, where the custody of an 11-year-old boy was at the center of a deeply contested legal dispute between his biological parents. The Supreme Court has reversed its earlier decision that had granted permanent custody of the child to the father and has now restored custody to the mother after serious concerns were raised about the child's mental health. A bench of Justice Vikram Nath and Justice Prasanna B. Varale allowed the mother's review petition, citing fresh evidence, including psychological reports that showed that the child was suffering from anxiety and emotional distress after being separated from his mother. Now, ordinarily, review petitions before the Supreme Court are only allowed in very limited situations, such as discovery of new and important evidence or a clear error on the face of the record. But in child custody cases, the court said a flexible approach is needed and the child's best interests must come first. This case goes back to a marriage that ended in divorce. The couple was married in 2021 and their son was born in 2012. After separating, they agreed that the mother would have custody and the father would get visitation rights twice a month. The divorce was finalized in 2015. The mother later remarried and had another child. She lived in Thiruvananthapuram with her new husband and both children. In 2019, she contacted the father to get his signature for the child's international travel, which is when he learned about the second marriage and the plan to take the child to Malaysia. Worried about the relocation and a change in the child's religion, the father moved the family court for permanent custody. The mother countered with her own application to take the child abroad. The family court in October 2022 ruled in favor of the mother, granting her permanent custody and allowing international travel during school holidays. The father was given limited visitation rights. Both sides challenged this decision in the Kerala High Court, which in October 2023 ruled in favor of the father. The High Court held that moving the child to Malaysia would not be in his best interest and granted him the custody with visitation rights for the mother. The Supreme Court initially upheld the High Court's order in August last year, but the mother then filed a review petition pointing to new psychological assessments showing that the custody change had caused significant harm to the child's mental health. One report dated September 3rd last year from a clinical psychologist stated that the child was showing signs of anxiety and was at high risk for separation anxiety disorder. More reports followed, confirming his ongoing distress, including fear that he would be taken away from his mother. The court also took note of allegations that the father made threatening remarks to the child after the judgment, which, even if unproven, further worsened the child's condition. The court held that these psychological reports were genuine and new evidence, and that the changes in the child's condition directly impacted his well-being, which was the reason enough to review the earlier decision. It said that the child has lived exclusively with his mother since he was 11 months old. He saw her as his primary caregiver and had formed a family unit with her and her new husband and his younger siblings. Meanwhile, the father, though wanting to reconnect, was someone the child barely knew and had never even spent a night with. So the court has now held that moving the child's custody to the father would destabilize the child and cause further trauma. So it has allowed the review, restored the civil appeals, and set aside the High Court's order. Custody was granted back to the mother as originally ordered by the family court back in 2022, though with some modifications now. Like, the mother will have permanent custody and the father will have both virtual and physical visitation rights. However, she cannot relocate the child abroad except during Onam, Christmas and half of summer vacation, and only with prior notice to the family court and the father. The court also directed that both parents must attend psychological counseling and get a fresh psychological evaluation done by the CMC Vellore by October this year. And finally, the court has advised both parents to communicate better, avoid letting past disputes affect the child, and cautioned the father against making any insensitive remarks. The court made it clear that the child-father relationship must be built slowly, with patience and empathy. Next, the top court has now stepped in again to check if its clear directions on enrollment fees for lawyers are actually being followed by state bar councils. The court has passed an order asking the chairman of the Bar Council of India, Senior Advocate Manan Kumar Mishra, to be present in court and assist in finding out whether the bar councils across states are complying with the Supreme Court's previous judgment delivered on 30th July 2024. That judgment had made it absolutely clear that state bar councils cannot charge enrollment fees beyond what is laid down in the Advocates Act 1961. Specifically under Section 24, the enrollment fee must not exceed Rs 750 for general category advocates and 125 rupees for SC or ST category advocates. The case at hand is a contempt petition filed by the petitioner in person, KLJA Kiran Babu, who argued that despite the Supreme Court's binding directions, several bar councils are still charging exorbitant fees. The matter came up before a bench led by Justice J.B. Pardiwala. When the bench asked the petitioner how he was personally affected, that is, what was his locus standi, he responded that anyone could move a contempt petition in such a case. The bench did not go further into that debate for now, and it chose not to issue notice in the contempt petition, but still took the matter seriously enough to ask the Bar Council of India to explain. For your better understanding, let me also tell you that the directions under the 2024 judgment were quite specific. State bar councils cannot charge enrollment fees beyond what is expressly permitted under Section 24 subsection 1 clause F of the Advocates Act. Bar councils, including the Bar Council of India, cannot demand any extra charges or fees apart from the legally permitted enrollment fee and stamp duty. Charging excess enrollment fees violates Article 14 and Article 19(1)(g) of the Constitution. And finally, the court had clarified that this decision would be prospective only, meaning that bar councils don't have to refund excess fees collected in the past, but they cannot continue this practice going forward. Interestingly, earlier this year, the Bar Council of India had filed an application asking the court to increase the enrollment fee to 25,000, a massive jump from the current legal limit. Well, to all the lawyers watching out there, tell us in the comment box how much enrollment fees did you pay? In a major legal development today, the Bombay High Court has upheld constitutional validity of the Unlawful Activities Prevention Act, or UAPA, and also Section 124A of the Indian Penal Code, which criminalized sedition. A division bench of Justices Ajay Gadkari and Dr. Neela Gokhale delivered the verdict, stating clearly that UAPA in its present form is constitutionally valid. With this, the court has put to rest, at least for now, the questions raised about the legality of these controversial laws. The petitions were filed in the context of the Elgar Parishad case, an investigation being handled by National Investigation Agency. The main petitioner, Anil Babura Bele, had been issued a notice by the NIA in July 2020 and challenged both UAPA and Section 124A on grounds of being unconstitutional. His counsel had argued that UAPA gives unchecked powers to the executive, allowing government to brand individuals and organizations as unlawful without a clear definition in the law. This, they claimed, violates fundamental rights and due process. But the High Court has now firmly rejected those arguments. While the detailed reasoning will be available once the judgment copy is published, the operative part makes it clear both UAPA and sedition law survive constitutional scrutiny. For your knowledge, I must tell you here that Section 124A of IPC, that is sedition, had already been under reconsideration by the Supreme Court, and its application remains temporarily suspended as per Centre's earlier submissions. Under the new Bharatiya Nyaya Sanhita 2023, which has replaced IPC, we don't get to see the word sedition. But BNS Section 152 introduces a new offence that criminalizes acts endangering sovereignty, unity and integrity of India. And the punishment is imprisonment for life or imprisonment up to 7 years plus fine. In another ongoing custody dispute, the Supreme Court today directed authorities to urgently trace a 5-year-old boy who was last in the custody of his Russian mother and has since gone missing. Acting on an application filed by his father, who is an Indian, the court ordered that the mother must not be allowed to leave India and that both she and the child must be located without delay. The bench of Justices Suryakant and Joymalia Bagchi was told that the Russian mother and the child have vanished into wilderness and are untraceable since 7th July, the day the child left school, and never returned. The father alleged that after 7th July, the child was neither taken for his scheduled medical checkups nor sent to school. He also claimed that his own lawyers were misled about the whereabouts of the child by the opposing side. The most startling claim was that on 4th July, that is days before they went missing, the mother was seen entering the Russian embassy in Delhi through the back door, along with a Russian diplomat with whom she is allegedly in a relationship. Following this, she became completely unreachable, prompting serious concerns about the child's safety and her possible exit from India. Taking strong note, the court ordered Delhi police to trace the child and hand over custody to the father. It also directed ministries of Home and External Affairs to issue lookout notices and seize the mother's passport. Officers have also been asked to speak to the Russian embassy to seek permission to enter the diplomat's residence where the mother was last seen. The court expressed doubt over the bona fides of the mother's legal counsel as well, calling their responses evasive and warning that even the lawyers could face serious consequences if they were found to have played mischief. The couple had been living separately in Delhi with shared custody of the child as per the court's earlier orders. But following these recent developments, the custody dispute has taken on a far more serious and urgent tone, with international and diplomatic sensitivities now involved. While the court has also made it clear that if any embassy officials are found involved in wrongdoing, the law will take its own course.